Today it's quite an important topic. The topic is case regarding Bilkis Bano. Okay. First, listen here. Whenever the I'll allow you or dictate you the notes after this, because this is quite an important topic which will be indicating us to some very potential polity topics. Okay. What happened is, this is something regarding Bilkis Bano case. Done. In the year 2002, we all know something happened in the month of February in 2002. You guys were born by then? You were there by then? Good. So, 2002, there is a couple of events happened. One thing is the burning of Sabarmati rail express. So, those people who lost lives in the burning of Sabarmati express were car sevaks. They were car sevaks. In retaliation to that, violence erupted in parts of Godhra in Gujarat. Okay, in parts of Godhra. So we actually, the other name we call for these riots are we also call them as Godhra riots. Okay, you must be listening to it in the news for quite some time. So, as a retaliation to that particular incident, violence has erupted in Godhra. What sort of violence is people? There are many versions of this particular case, but we'll go as per the facts. One thing is, certain community of people, one community of people who are being targeted. So, fearing for her life and life of a family, this woman, Bilkis Bano, actually fled her village. She fled her village, and while attempting to escape all this violence and fearing for her life, she was caught by few people. And she was escaping with somewhere around 15 members of their family members, and this particular woman and her child, her 3-year-old child. Okay, and this woman was pregnant at the time. So the accusation was, the crime that was committed was, they murdered, those people who caught hold of this woman, they murdered almost all the family members. Those who were left alive were this woman, the child, and one other family member, I guess. So all other family members were killed by them. Okay. So in that case, there is a case of murder, right? And the other crime that was committed was rape. She was raped while being pregnant, which is considered a heinous crime in today's parlance or today's judiciary. So this is the case with respect to that. This happened in the year 2002. Okay. So what happened? The case went and NHRC took up this case and a CBI inquiry was ordered. So CBI was asked to take up this case. CBI took up this case, and in the year 2004, arrests happened. People were arrested. Those involved in this crime were arrested. And the trial of this happened in Gujarat, right? The crime was committed in Gujarat. But the trial was moved to Maharashtra from Gujarat. Why? The reason being, she was receiving death threats during these 2 years of time. The crime was committed in 2002 and the case went up, people were arrested in 2004. During this time, she was receiving death threats. So in order to ensure an impartial investigation and impartial trial, the trial was moved to Maharashtra from Gujarat. Fair enough? Understood, guys? This is the case. Just we'll be indicating certain things later on, but for now, understand the case. And then in 2008, the trial was over, and a special CBI court sentenced 11 accused sentenced 11 accused into life imprisonment. Life imprisonment for the crimes they have committed. Life imprisonment, that means the rest of the life they will be in prison. Okay. And 7 were acquitted. 7 were acquitted. That means 7 people were set free for the lack of evidence, because they said that there is no proper evidence indicating these 7 people, but 11 accused were convicted to life imprisonment in the year 2008. So that's how it is. That is when they went to jail. And what happened is, in 2017, we all know the case was moved to Maharashtra, correct? So under which High Court jurisdiction now the case is? Under? See, be very specific while naming the High Courts. Understood? The name of Calcutta is changed to Kolkata, but the High Court still remains Calcutta High Court. The name of Madras is changed to Chennai, but the name of the High Court still remains Madras High Court. In the same way, this is Mumbai today, but the name of the High Court is Bombay High Court. That you must be very clear about it, because being civil servants, you have to remember that. So the Bombay High Court in 2017 has upheld the judgment. What was the judgment? What was the judgment? Life imprisonment. Has upheld the judgment. And in 2019, this woman Bilkis Bano was awarded rupees 50 lakhs in compensation. 50 lakhs in compensation for the mental trauma she has gone through, for the loss of her family, for the loss of the breadwinner of her family, for various other reasons. She was given 50 lakhs as compensation for all the trauma and the torture she has gone through. This is the first ever, and first and the only time a compensation was granted in this particular case. That's the reason I mentioned it. Okay, this happened in 2019. So what happened in 2022? 2022, what happened? In 2022, one of the, let's go to the next, another slide, okay. Okay, in 2022, one of the accused, one of the convict, he approached the courts. He approached the courts. What else? He approached the Supreme Court. He approached the Supreme Court saying, I have spent 15 years in jail. I have spent 15 years in jail, and now I may be eligible for remission. He asked, I want my sentence to be cut down, or I want to be released because I have already spent 15 years in jail. Okay, what the Supreme Court said? So Supreme Court said that this decision must be taken by the government of the concerned state. The concerned state is Gujarat. Why Gujarat is the case over here? Because the crime happened in Gujarat. Understood? Then immediately once this petition was put out, and the petitioner, whoever want to be issued the remission, whoever wanted the remission, he went to the government. He petitioned the government, and government of Gujarat appointed a committee. They established and appointed a committee to review the sentences of all the 11 accused, or all the 11 convicts. We call them convicts now because they are in jail after the trial is over. And this particular committee has favored remission, has taken the decision in favor of remission of those particular 11 convicts, and they were released somewhere in 2022, probably July, August, I don't remember the exact time, during that time. So between April and July last year, in 2022, they were released. Understood? Based on what recommendation? Based on the decision of the concerned government of Gujarat. So there the remission happened, and this remission was criticized for many reasons. What happened yesterday was, again the case went to Supreme Court. Again the case went to Supreme Court. Supreme Court reversed this decision. Reversed this decision of the concerned decision of the committee appointed by the government. So now what happens? These particular, those 11 convicts who were free, who were given remission and who were free out of the jail. They were free, they were released. You guys remember? No, right? Who were released and who were out in the society, now they have to return back to the jail within 15 days. Within 15 days. But they have one legal option. Okay, they have one legal option. What is that legal option? Since the case was heard in Maharashtra, now they can approach the Maharashtra government. How they approached the Gujarat, how they approached Gujarat government for remission of their sentence, they have this legal option. It's a legal option. Like, it's still discussions are going on if the legal option is valid or not, but it is clear that they may be approaching the Maharashtra government for remission. Understood? But few experts say it's unlikely that they may be given, they may be set free by the Maharashtra government. See, understand this. Gujarat under its rules of jails and prisons has set them free based on the committee's report. But it is unlikely for Maharashtra to set them free. Understand this? Why it is different for both the states? Why it is different for both the states? Come up, guys. Why it is different for both the states? No, you shouldn't be saying that. That thing you have to keep in your mind. But fair enough, it's in our class. Fine. That should be there in your mind, because see, there is certain amount of politics attached to it. We all know, but we shouldn't be discussing it. Fair enough. Like, good that you have that in your mind, because that kind of thought process will actually help you make certain decisions also. Like, you'll try to learn that in future. But tell me why there is, like, see, they were outrightly released by the Gujarat government, but now in Maharashtra it's unlikely that they may be released for the crime they have committed. See, for the quantum of the crime they have committed is they were given life imprisonment for a heinous crimes of murder and rape of a pregnant woman, which can be considered in some cases as a rarest of rare cases. Like, that's very gruesome, right? Attempting rape on a pregnant woman, and it's not just rape, it's gang rape. Like, around dozen people going on. It's like cruel. It's really cruel. So it can be called rarest of the rare cases also. The reason behind one state acting in one way with respect to the release of the convicts, and other state may not be releasing the convicts, is because the prisons is a state subject. Understood? Prisons is a state subject. That means every state has its own rules with respect to prisons and jails. Okay? It has its own rules with respect to release or remission of sentences, or application for the remission of sentences, or going out on parole, or giving bail and releasing the convicts. All these things, it differs from state to state, because prisons is a state subject. That's an important polity point number 1 for us. Now you have understood everything with respect to the case, right? And we have indicated one polity topic out here. Now we will see throughout the case how our polity can be linked to it. First thing, come on guys, articles. Article? No, President, Governor. Article? What are these two articles? Article 72 and Article 161. They are the pardoning powers of President, Governor. So, under these two articles, the pardoning powers of President and Governor are clearly given. So, can Governor commute or remit a death sentence? He can commute. Understand? He cannot pardon any death sentence. Okay? And what is one thing that doesn't come under the purview of Governor? With respect to martial law. Understood? So, these two articles are important for us here. And two more things, two more cases that are important for us is Maruram versus Union of India case. Maruram versus Union of India case. Understood? In this particular case, what Supreme Court told is the president or governor cannot exercise this power of pardoning or power of commuting or remission by themselves. They have to take the advice of the concerned government. What are the concerned government for president? The government is central government, union government. For the governor, the concerned state. They have to take the advice of, they cannot act on their own with respect to the pardoning power or remissioning, with respect to the pardoning powers which both of them have, but they have to take the advice of the appropriate government, and this decision of the appropriate government is binding. This decision of the appropriate government is binding on the concerned president or the concerned governor. Understood? This is Maruram case. And there is one other case, that is Kehar Singh versus Union of India case. Kehar Singh versus Union of India case. Understood? Kehar Singh versus Union of India case, it says that the power of pardon which is mentioned in the constitution, which can be accorded by the president and other pardoning powers by the governor, is a matter of grace, and it's not a right. Understood? It's a matter of grace, like means out of compassion or something the president must be providing, but it is not the matter of right. Okay? Understood? Kehar Singh versus Union of India case. So these are few things. See, whenever in polity there will be articles, there will be certain laws for implementation of few articles, and there will be certain court judgments for implementing those things. These are the two court judgments. There is one other court judgment with respect to Bilkis Bano case, that is this case, Lakshman Naskar versus Union of India. Lakshman Naskar versus Union of India. In this particular case, the Supreme Court has laid down 5 principles. It laid down 5 grounds for remission of a particular sentence. Okay, that means Supreme Court said that while taking decisions with respect to remission of any particular convict, the governments cannot act arbitrarily. It cannot act on their whims and fancies. They cannot take any decision whimsically and take an arbitrary decision, but it has to follow certain grounds. It has to satisfy a person for remission, a convict for remission has to satisfy certain grounds. It has laid some 5 grounds in this particular case, in case of Lakshman Naskar versus Union of India. Understood? There are 5 things you may remember or you may not remember. That means it depends upon whether the offense is an individual act or an offense against the society. See, whenever a person is committing dacoity or some pickpocketing or something else, it doesn't actually affect the society at large. Who is at loss? That person is at loss, and who is at gain? Who thieved who has committed the act of stealing. But if crimes like rape, crimes like murder and human trafficking, all these have the impact on the society. So while giving remission or while awarding remission to a person, you have to take into consideration what crime he has done, and if the crime has a reflection on the society, has an effect on the society or not. And the other thing is like, is there a chance of that person committing crime again? Can that person be a repeat offender again? That is one thing it has to consider. And the other thing is, convict has lost the potentiality to commit it. Like, you have to see whether if that particular convict is still able to commit that crime or not, or he has lost the potentiality to commit that crime or not. See, once if a person is in life imprisonment and attains an age of somewhere 60 or so, he doesn't, like, you can always say that he may or may not be able to commit some crime if he's in wheelchair or if he's bedridden or so. At that point of, that's what he means. At that point of time, they may consider for a remission. And if there is any other purpose that this person cannot be released out, shall not be released out of jail, they can keep him in the jails again. And socio-economic condition of the convict's family has to be considered. If this person is the only breadwinner of that particular family, or if that family is unable to survive outside in the society, if this person stays in the jail, that can be considered. So, understood? So this is with respect to the cases. What are the three cases we have discussed? Maruram case, Kehar Singh versus Union of India, which says the pardoning power of president or governor, or remission power of president or governor is a matter of grace and not a matter of right. And in what you said is with respect to Maruram case, understood? And with respect to Lakshman Naskar case, the Supreme Court has said that the decision for remission cannot be arbitrary and cannot be at the whims of the concerned government, but the decision has to be taken based on by satisfying few criteria, and they set the 5 grounds for it. Clear? And what is the first thing we have pointed out earlier? The subject of prisons is a state subject. That means each and every jails in different states have different manuals to function. Understood? As per jail manuals, and one more thing that can be considered is his good behavior in the jails. That can be considered. Okay. States, no? Now we have seen that this is a matter of states and how states can remit based on section 432 CRPC. Section 432 of CRPC. Supreme Court held that states cannot exercise the power of remission arbitrarily, which I told earlier. And as per this particular section, sentence review board can be set up by the states. What is it? Sentence review board. That means they'll review the sentence that is awarded to that particular convict. And factors that has to be considered, that can be considered for review of sentences: seriousness of the crime. Someone like rape and murder were released, like God knows what can be more serious than this, right? So if taking that into consideration, seriousness of the crime, what general presumption will be? Those particular convicts should not be released, like in the Bilkis Bano case. But not only released, but they were welcomed with sweets and garlands. You can understand the kind of society and kind of people who are around them and all. So that's one thing you can do. And the status of the co-accused and conduct in the jail. Conduct in the jail can be the grounds for remission. With respect to this particular review board, Supreme Court has laid certain five criteria for the release. That is in Naskar Singh case. That is in Naskar case. Okay. In Naskar case. But here, with respect to CRPC 432, you have to consider 3 things. What is it? Seriousness of the crime and the status of the co-accused, and conduct in jail. These 3 shall be considered. And you all know which particular code is with respect to the conduct in jails. That is CRPC 432. And remember, jails is under the state subject. That is the reason the different states have different manuals with respect to, and they have different things, like different states are different with respect to applying allowing the convicts for application of mercy petitions. In this Nirbhaya case, what the jail administration did, they asked those convicts to apply for mercy petition, because all their chances of legal options were exhausted, and they asked them to apply for mercy petition when they were in Tihar. That is one thing. And in few jails, the release will be immediate after the judgment is released. Few states, they have to follow certain procedures. It's different from state to states. That is the reason you have a different approach towards the manuals how jails work.